Letter of administration in NY. When someone dies without a will in New York, the process of distributing their estate is governed by state law. To begin this process, a court must appoint an administrator. That appointment is made official through a document called the Letter of Administration. This legal document gives the administrator authority to manage and distribute the deceased's property. Legal framework for letters of administration. The surrogate's court issues the letter of administration after a valid petition is filed. The applicant must submit documents like the death certificate and a list of heirs. If approved, the court grants legal power to the administrator to act on behalf of the estate. The type of letter granted depends on the circumstances. Limited letters only allow specific tasks, while temporary letters are issued in urgent situations for up to 6 months. Ancillary letters are for estates with New York assets but where the deceased lived in another state. The authority of these letters includes managing property, accessing financial records, and distributing assets. Who can apply for a letter of administration in New York? When no will exists, close family members can apply in a set order of priority: spouse, children, parents, siblings, and extended relatives. If someone with higher priority, like a spouse, doesn't want to serve, they must sign a waiver. If multiple people have equal standing, such as children, they must either apply together or renounce their claim. Applying involves submitting a petition, paying a fee, and possibly attending a court hearing. If the petition is successful, the court will issue the letter, giving the administrator full authority over the estate. Understanding the letter of administration process. The application process begins by filing a petition in the county where the deceased lived. The applicant must include documents such as the original death certificate and proof of relationship. The court may require additional affidavits and could hold a hearing. Once approved, the administrator is empowered to take several actions: obtain a tax ID for the estate, open an estate bank account, settle debts, and transfer property. Without the letter, financial institutions and agencies will not release any information or property. It's also recommended to obtain several certified copies of the document, as many entities require originals. After the letter is granted with the letter of administration, the appointed individual can begin managing the estate. This includes collecting assets, paying debts, and distributing what remains to heirs. The court may also issue a certificate of appointment, which can be used for transactions with banks or government agencies. Each estate is different, and the type of letter required varies. That's why working with a law firm familiar with probate law is highly recommended. If you're navigating this process, Schlessel Law PLLC can help. With the guidance of an experienced attorney, you can avoid costly mistakes and ensure compliance with New York laws. Contact our law firm to speak with a lawyer who can assist you from start to finish.